What's up, guys? We got a great video from Men Dating channel. Evil ex-wife demands husband's new house as part of child support increase.
You're saying you don't have an income now?
Correct. And Dave moved to Tennessee. I think that's pretty major too. He bought a house in Tennessee.
That's not what his pleading says.
Excuse me?
Where does Mr. Reynolds live? He lives according to his response, he lives here in Grand Rapids.
When I requested this entire child support review, he bought a house in Tennessee and he still owns that house in Tennessee.
He can own a house in Tennessee, but if he's living here in Grand Rapids, that's not a change.
Well,
my only question here is, I need to know what his income changed because the job changed. So what information I need is this. I need information from his current contract. And if it is the same income, we do not have a change of circumstance, and we're stuck with the 36 months by law. That's my explanation, Ms. Lemon. That's why I tried to explain this. I'm like, I don't have the requisite change of circumstance to review child support at this time. You signed a contract in June of 2022. Essentially,
based on the information that David Reynolds was going to be, I was forced to sign that, claiming that that was the only way I could see my kids.
Unfortunately, but there was a lot to that agreement. They waived arrears.
Including the fact that I would be able to see my kids, because otherwise I would not be able.
And you are seeing your children, correct? You are seeing your child. Yeah. Okay. Then
only because I agreed to sign that.
You got the benefit of the bargain, and that's my problem. I don't have the requisite legal change of circumstance to review this unless his income increased. If his income increased, I will review this. So what I need is I'm going to reserve on that because I want that information. Once I get it, I'll issue an opinion as to whether there's a change of circumstance or not. Mr.
And he does not have the kid. He does not have her 50-50. And nowhere in my pleadings did I say it's about a 2-day difference. That was a benefit that I was giving him to try to resolve things outside of court.
Well, again, her pleading says overnights.
I know, that's what her pleading
says. It does not. Where does the pleading say that he only has 2 additional overnights? Please tell me where the pleadings say he only has 2 overnights.
I will look it up right now.
That's what I'm looking up too, because I know that I read it in your pleading.
My request was for the child support to be based on 2 different overnights, but that was because of a conversation I had with Dave, which he claimed he would be willing to do if I would swap.
Minor daughter, Kalinas, you have a typo. You probably meant defendant, but oh no,
no,
you
I didn't. No, I didn't. I meant I am the plaintiff.
You said 184
either one, your allegation number 3 indicates you guys have almost the same parenting time that was ordered in the previous order.
No,
that's your own allegation. That's your own.
Say that we
number
have the
3,
same
minor
time.
Daughter Kaliana Reynolds spends a minimum of 184 overnights with the plaintiff.
But yeah, that does not say that's a equal split by any stretch of the imagination. Nowhere there does it say that Dave then has 180
yes,
some.
it does, Ms. Lemon.
No,
yes,
it does not.
So I will reserve. Get me that contract. Let me see what the pay is. I will note the pay in the order. I'm going to let her know what that contract says. And if it says the $500,000 that you're alleging, there's no change of circumstance. Matter of fact, his pay went down $6,000. So,
thank you very much, Your Honor.
All right. Have a good morning, everyone.
Have a good day.
I'll to make
reserve
sure
after I see that.
The additional proofs that were requested, because I know last time that we sat before you, you would not allow me to show the video. That was very clear evidence, even though Jude himself had the exculpatory evidence.
Have you been in front of me before? I don't remember you guys.
Absolutely, we've been in front of you before.
All right, mostly
and you would not allow me to present anything, just like now.
Okay, well, you've presented what you presented. That's what you've presented it by your motion.
No, my motion very clearly says that I have a change of job. It very clearly says I have a change, both in my student status and in my job, that the father has a change, that it's not remained 50-50.
All right. Again, have a good morning. I'm going to reserve, and I will issue it when I look at his income. Have a good morning.
Thank you very much,
everybody.
Notice the reaction of the ex-husband when she was talking. Okay, it speaks a lot of volume. It's just quiet there and looking sideways. So the comment section, people are saying, how do the kids' expense go up just because he might get paid more? She's not there for the kids, but to line her own pockets. The first case, Why does this judge let this woman continually interrupt him? Allow her to be argumentative during a proceeding is ridiculous. How sad that children are used as pawn or a weapon to get one up on your ex is just despicable. 184 overnights out of 365 overnight a year is actually over 50%, and the dad's income dropped 6K in a year. Then he buys a house with his money after the divorce, and she wants part of that too. Wow. She doesn't have any say about his financial decisions. Get your own life, lady. Regarding the first case, I'm not remotely surprised they are divorced. There is only so much of a woman like that any rational male can cope with before mentally checking out. Why wasn't she arrested for the numerous counts of contempt? First, Karen, she wasn't pissed because she didn't get her way. She's a nightmare. These judges do everything they can to help these women financially. Grape men. Why does she get child support if they are 50-50?
Would you like the court to award you a judgment, $13,476.88, to make up for the excess amount of child support that has been garnished from your check?
Yes, sir.
All right, and would you like the court to award you attorney's fees since you had to hire me to get this money back?
Yes, sir.
Is there anything else you think the court should hear today, Mr. Guy?
No, sir.
I have no further questions for this witness.
All right, Mr. Diamond.
No questions, Your Honor.
All right, at this time, Ms. Williams, technically you're your own lawyer. I always have pro se litigants, if they have questions, they have to run them through me because I want to make sure that they're relevant. So at this time, ma'am, as your own legal representative, do you have any questions, Mr. Guy?
No, I don't have any questions, sir, but I do have a statement.
All right, well, that's at the very end, ma'am. Thank you.
Okay.
All right, so Mr. Starr, you can call your next witness, please.
All right, I'll call Ms. Williams, please. After your son graduated high school, did you continue to receive those child support payments?
I did.
All right. Have you returned any of the excess money since your son graduated high school to Mr. Guy?
No, I have not, sir.
Why?
No further questions, Your Honor.
All right, Mr. Diamond.
That's what you're about.
Yeah. What are the reasons why you didn't return the money, Ms. Williams?
The reason I didn't return them, sir, in December of 2020, I was notified by the Texas Child Support, and they told me that my case was no longer a court-ordered case. And they also told me that my son's father was always also notified. So how did I know he wasn't doing that on his own to rectify or compensate for what he wasn't doing for my child?
I'm sorry. So the point you're trying to make is that his contribution to your son growing up was insufficient, and this was maybe a way of trying to make things right?
Absolutely, sir. Child support only started in 2011. From 2011 before, I was doing that on my own. He chose when to take care of my child.
Okay.
So it sounds like it's an equitable argument that child support didn't go back far enough when it was initiated.
It did not. We have 9 years where I did this solely on my own. I mean,
objection, non-responsive. This is narrative.
All right, here's the deal, ma'am. Yeah, that's not going to fly. Again, this is kind of straightforward. That you should be granted some type of credit for, as far as the overpayment is concerned, ma'am.
Absolutely, sir.
All right, what's the reason, ma'am?
Emotional, physical needs. I mean, he was never there for my child. It's more to take raising a child than finances.
Yes, ma'am.
I mean, the medical bills, the dental, all of these things.
Okay, ma'am.
May I ask the witness a few more questions, Your Honor?
Go right ahead.
are you in good health currently, Miss Williams?
I am, sir.
Do you have other family members who have health issues?
I do, sir.
Are they close family members?
Sir, I do. We just lost an auntie just Saturday. Yes,
So I take it you help pay for some of the funeral costs?
I do. I have custody of my nephew as well. I lost my sister. I'm raising him as well.
How old's your nephew?
He's 11.
Okay, here's what I'm getting at. You would have to show that it's a hardship for you to repay this $13,000. So is it a hardship for you to repay the $13,000?
It's not, sir, but why should I be obligated to pay something that I feel like I didn't take?
Okay, here's the deal, ma'am. That you feel is not going to meet the legal standard for me to not order this, ma'am. Again, I've got to have some reason at law. I know you're not a lawyer, but you didn't retain counsel. I gave you the opportunity to do so, and I've got to hold you to the same standard. And right now, I'm not hearing anything that's going to get you to a legal standard of giving some type of forgiveness. I'm going to let the states continue to ask questions, but again, you can't. I've known people for years who they don't do it. They don't have a darn thing to do with their kids. All they do is pay the child support. And I've been saying for years, the only thing I can order is child support. I can order it based on what the law says I'm supposed to do, and I can't make somebody be a parent. That's not within my purview. So unless there's a legal reason, ma'am, that the money, and again, I know you're not a lawyer, but I got to hold you to that standard. Unless there's a legal reason for me not to order it, ma'am, then I'm probably having to look at orders. So is there a legal reason that you know of, ma'am?
It's not, sir.
Okay. All right, you may proceed, Mr. Diamond.
I don't know if there's much more I can add at this point, Your Honor.
All right, then.
A pass witness, sir.
Okay, anything on redirect, Mr. Starr?
No further questions, Your Honor.
All right, first off, I got to ask, obviously, we all sitting in here. I don't think, does the state have any witnesses that the state wishes to call at this time?
No, Your Honor.
You heard testimony from my client saying that there is an overage. The OAG confirms that there is an overage. He said my numbers were correct. And Mr. Guy has said he's not been paid back. And Ms. Williams has agreed with that assessment that there is an overage and she has not paid it back as well. The overage is $13,476.88. And attorney's fees before this hearing began are $5,808. That would make the total judgment, if my math is correct, $19,284.88. And we would just like to request that amount in our favor, Your Honor.
Okay. All right, folks. Again, this is kind of a straight out accounting one. What I'm going to go ahead and do, I'm looking at having to find, obviously based under the Texas Family Code, that the money that it appears to be uncontroverted, that the funds were paid to Ms. Williams, and they were in excess of the child support amount after the date of graduation and the child turned 18. So the court will reduce the judgment that unpaid amount. I am going to do a 48-hour return on this one, where I can actually see. I need to look up what if it was child support. I know what I would have to do as far as the repayments are concerned, but I'm not sure how this sets up. It's just a straight out judgment. How much I've got to order the repayments to be as far as the monthly amount is. There's still going to be judgment interest on this, and I've got to double check what the standard judgment interest is, because I know the Attorney General and this court has its own interest amount. So I'll have to double check that to see what that is, and that way I can get the make a ruling on what that repayment would be to try to do it over a certain amount of time, if that's also provided for under a normal civil action, and what that amount needs to be as far as covering the interest. And I got to see what the court has to do as far as attorney fees and getting that set up. Is that part of the judgment, or is that something separate? Mr. Starr, do you know off the top of your head, sir?
Off the top of my head, no. I'd have to look it up as well, Your Honor.
All right, here's what I'm going to do. I'm going to go ahead and reset this. Let's see, I think I already got a 1045 on Thursday, and I was going to use this Zoom code. But I'll either do it at 10:35 or 11:30 on Thursday. Okay, no, I do not have a 10:45 on this Thursday at the general docket. So what I'm going to go ahead and do is move that and see what we're looking. Okay, no, I do not have, and I was going to use this Zoom code, but I'll either do it at 10:35 or 11:30 on Thursday to see what to get these amounts down pat and see what we're looking at. Okay, no, I do not have a 10:45 on this Thursday at the general docket. So what I'm going to go ahead and do is move this Zoom code to that 10:45 time slot, and everyone can check in without having to go in through the main docket on that day, which with the 40 or 50 cases we had at that time. So anyway, folks, I'm looking at doing the judgment, but I got to figure out what the repayment amount is, and I've got to figure out what the interest is, and obviously that will be placed in your order, Mr. Starr. And if you can double check that and find that out, I'll allow you to present that to the court at the time, and I'll make the ruling as far as attorney fees going forward.